in the Clean Water Act, the federal government tells the states, you have responsibility for protecting the cleanliness of your water. So the state is delegated the authority by the federal government to protect the water quality. And so what this lawsuit says is you're not doing your job, the state of Florida. Well, of course, the state of Florida disagreed, and for 3 or 4 years, there was a lot of battling back and forth. The lawsuit was battled, and any of those of you who were around in the 1990s, the early 1990s, millions of dollars were spent on lawyers by both the state and federal government to battle that lawsuit. In 1992, though, well, actually 1991, there was a new governor elected. Let's see how many people have been around long enough to know who that was. Bob Childs, who came into office and decided to throw down the sword, or lay down the sword, rather would be the better analogy. And he actually went into a federal court hearing right in the middle of this battle with all the lawyers and kind of walked in, literally, and in a 5-minute talk in 1991 told the judge, the state of Florida is putting down our sword. We believe there is a water quality problem, and we want to work with you to solve it. And so, for the next 6 months, everyone got together and crafted an agreement that would be the roadmap forward on how to solve our water quality problems. So in 1992, a settlement agreement was written, actually in 1991. And it was submitted to the federal judge. Yeah, come on up. It's a lot warmer right here. That's right, we need to have a little fire. If I put a fire here, we'd have 100 people here. So in 1992, the federal judge said, okay, I think your agreement's a good one. And the federal judge issued what's called a consent decree. It's a court order that's binding on everybody. And everybody signed the settlement agreement. So the federal judge said, okay, I'm now going to require you to do all these things you've agreed to. And I'm going to tell you the big things that we all agreed to do. Number one, the farmers had to promise to do something called best management practices, where they do better fertilizer application practices, better nutrient removal practices. So on their farm fields, they promised to remove at least 25% of the phosphorus, which is one of the nutrients. They promised to remove at least 25% that was going to be coming into the Everglades. They promised to do that. The second thing was that the state of Florida, with help from the federal government, agreed to build 40,000 acres of artificial wetlands on state lands just north of the Everglades and the rest of the Everglades down south to help clean up those nutrients before that water got into the Everglades. So over a span of 10 years, the state and the federal government spent about $1.5 billion to build these stormwater treatment. Wait just a minute. So over a span of 10 years, from 1994 through 2005, roughly, you spent, meaning all the taxpayers of Florida and the federal government spent about $1.5 billion to build those constructed wetlands. Another thing the consent decree required was that we were going to do, the scientists were going to do a lot more research to determine what is the threshold number of phosphorus, what is the magic concentration above which further harm to the Everglades is going to occur. So a lot of money put in over 7 or 8 years to do scientific research to establish a threshold concentration of phosphorus. So that phosphorus threshold was established and is now part of the state law. And the magic number is 10. You don't need to know anything else other than it's 10. I'm going to explain a little bit more, but if you remember 10, it's 10 parts per billion total phosphorus. So I'm going to explain what that means. That means, the magic number means that in 1 billion parts of water, so let's say in 1 billion gallons of water, you can only have 10 gallons of phosphorus. So 10 parts of phosphorus per billion parts of water. That's a very, very, very low number. And but it's what the Everglades evolved under. Actually quite less than that even. And so the state has agreed and made it a state law to promise to achieve that concentration of total phosphorus in any water coming into the Everglades. Isn't that for the speaker? I'm not sure that's kind of...
Your order is coming to your analysis.
So, that was required in the consent decree, in this thing that we all signed off and agreed on. It was agreed that by December 31st, 2006, any water coming into the Everglades would meet that 10 parts per billion number. And we actually thought, when we agreed to this number back in the early 1990s, that it would be relatively easy to do. We still had 10 years to go. We said, sure, we can think of technologies and best management practices that will get us to 10 by 2006. Originally we said 2005 or 2001, but we changed it to 2006. Well, the bad news is we haven't got there. You know, we've made a lot of progress. The state has spent a lot of money, and the constructed wetlands, two of which are just north of us, by the way, they were just off State Road 80, Southern Boulevard. You see them if you drive out to Everglades. You see a big, huge pump station on the left-hand side as you're heading out to Everglades before you get to the farm field. That's actually an inflow pump station to one of those constructed wetlands. They're doing really well. They're removing 70% of the phosphorus that's coming off the ag fields before it gets into the refuge. So, if you look at it from that way, we're doing a great job. The bad news is that to achieve that 10, you really need to remove about 95% of the phosphorus. So despite all the work's been done, they're only getting 70% reduction when we need to get to 95%. And so now, there's a big battle going on in the courts, in the federal courts, because the state believes they've done enough, that that this is going to be enough to achieve, that we just need to wait longer, that all the measures that have been put into place are going to be enough. The federal government believes, great job, you've done a lot of good work, but unfortunately more needs to be done, and in fact this consent decree that was issued by a federal judge says if you don't achieve that target in 2006, you have to do more. And so, right now there's a big battle going on, and the state government is fighting the federal government in court about that. Now, they're not the only ones involved in the battle, because the agricultural interests, are on the side of the state government, because they're worried that if further reductions are required, it's going to cost them more money, and the price of their product will go up, and their profit will go down. And we all eat. I mean, I like sugar. That's one of the big crops over here, vegetables. So we all are, in a way, a part of the problem. But of course, the agricultural community believes that the state government is right, that we've done enough. There's another bunch of groups, the other interest in the lawsuit. The other people in the battle are the environmental groups. There's some representatives here from some of those environmental groups, I won't mention any names like you see in front, who have filed petitions and motions in this lawsuit agreeing with the federal government that more needs to be done. And finally, there's another very powerful interest group in this lawsuit, and that's the Miccosukee tribe of Indians in Florida, who also believe that more needs to be done. So this is very active litigation that's going on right now, and you will in the next few days see some newspaper articles on it, because in fact, right now, Mike Walden, I'm going to point him out right here, he works for the Fish and Wildlife Service, he's one of the experts, he's a hydrology expert, and we are working right now, today, yesterday, today, and tomorrow, preparing for the next set of hearings that are going to go on in the court hearings that are involved in this case. And there's actually 2 different court cases going on right now in federal court related to this, so it's going to be very interesting over the next few months to see how this all resolves itself, because if you take one possible outcome, one of the federal judges has come very close to finding both the state of Florida and the federal government in contempt of court for not achieving the water quality goals. And if the judge, which a judge has complete power to do this, a judge could levy huge fines against the governments involved for not achieving the targets that they're supposed to achieve. So that's one possible outcome. If we were to prevail and convince the federal judges involved that more needs to be done, literally in the next 10 years, the state could have to spend another $1 to $2 billion to try to get the nutrients down to a level that are not going to continue the further harm to the Everglades. All the way on the other end of the spectrum, if the state were to win, it would mean that they would say, we've done everything we need to do, you just need to wait longer. Or they might also argue that it's not possible to get any further reductions in water quality, or any further improvements in water quality. And of course, any number of things can happen in between. Yeah, that's a very good question. If they, one outcome is that Congress could introduce amendments and weaken the Clean Water Act, which certainly is a possibility. Probably that would take long enough and would not affect the lawsuit as it currently stands. That is possible, but the fact is that that's the reason why in this country we have three branches of government. We have the judicial, the legislative, and the executive, right? So in this case, the judicial branch, the courts, has issued an order that cannot be overruled by Congress or by the executive branches of government. And it's kind of interesting. Even right now, the federal government filed the lawsuit in 1988. Even right now, the federal government, for whatever reason, said, we don't want this lawsuit anymore. We think enough's been done. It's too bad. If we told the judge we've changed our mind, it doesn't matter, because now it's a court order. And what would have to happen is not only would the federal judge have to agree, but all the other parties in the lawsuit, the environmental groups, the Miccosukee tribe, the agriculturalists, everybody would have to agree and then convince the judge that we want it out. So the nice thing, in a way, is that once we've all signed our names to the parties to the lawsuit and made a promise, you can't just change that. And so that's the sort of battle that's going on right now. And the downside of all this is there's, of course, I'm very interested in seeing cleaner water in the Everglades. I would rather see this solved without having lawsuits involved. Because lawsuits always, sometimes the outcome of a lawsuit, even when it's in your favor, is not exactly what you'd like it, how you'd like it to happen. But I would like to see us be able to solve these problems without going to court. But the problem is now we put this problem off for so long. The cost to fix it now keeps going up and up and up. And the Everglades continues to go down and down and down, still being impacted by these nutrients. And so right now, if that federal judge were to, there's two separate court cases, but if they agreed with us, and in this down economy, force the state to do at its maximum what it should be doing, spend $2 billion over the next 10 years, that would completely shut down every other restoration activity that the state would be doing. I mean, it would be, there's not enough money right now in the state's offer to do what we're asking them to do. Now, we don't think that's our problem. We think the state has to go figure out how to do that. There's one group that would argue, well, okay, the state government doesn't have the money. Maybe we should be asking for more money from the source of the pollution, which is the agricultural community. And maybe they should be paying more for this additional cleanup. And of course, the agriculture community is going to disagree very strongly with that, because that cuts more into their profits and their bottom line. So that's where the battle lines are right now. I have my own very strong opinions. I know Mike doesn't have any opinions about this. I have my strong opinions about what we should do, but you have to keep in mind there's very divergent and very strongly held opinions on this whole issue, ranging from we've done enough, we've spent way too much money already, we've about run agriculture out of business, the state's out of money, we can't do any more, all the way to the other end, that if we don't do something about this, the Everglades, as we know, won't exist for very much longer. And so that's kind of where we are right now. And that, remember, I focused only just on the water quality problem. Remember, I mentioned 4 other things that we also have to solve at the same time. So my belief is that any one of these things that threaten what little Everglades we have left that actually are Everglades, and we need to be working hard on all of these fronts. And it's a challenging thing. And one of the biggest challenges is the Everglades that we're trying to protect, especially Everglades National Parks, way down at the end of the state, right? It's at the bottom end. It's at the downstream end of everything we do. And the challenge is that this very sensitive ecosystem is downstream. The water flows downhill. Unless we change that, the water still flows downhill. And so it's so important that we solve the problem up here, north, before that water gets south into the Everglades. And I just wanted to sort of lay out, it's a very active, like I said, it's a very active thing going on right now. And you know, it sort of plays out in the background. The environmental groups, all the interest groups are very aware of it. But the general public, I think, is completely unaware of this subject. That's why we're glad you're here with us, listening to this, understanding what the different perspectives are. I know everybody's free.